The decision of Supreme Court in Hyatt International case explains and revisits permanent establishment, which is an important concept in international taxation. Hence, the decision is an important milestone to appreciate this critical concept. Let us take a step back to appreciate the nuances and why this case unfolded. Under international taxation, the rules are generally set out in bilateral tax treaties, which in India we colloquially understand as DTAA, which stands for Double Taxation Avoidance Agreements. Under these DTAA, the taxation powers are distributed between the resident state and the source state. As regards taxation of business income, the power to levy taxes on non-resident is limited with the source country, and it is only when a permanent establishment of the non-resident exists in the source country that the source country can tax the non-resident. Hence, it is important that a permanent establishment must exist before the source country can exercise taxation power over the income of the non-resident. It is in this context that different treaties provide different rules. Some treaties provide for service permanent establishment. Some treaties provide for construction permanent establishment. Invariably, most treaties provide for fixed establishment permanent establishment, or as we commonly say, fixed establishment PE. The decision in Hyatt International deals with this aspect of permanent establishment, namely fixed establishment PE. The judgment actually follows the landmark case of the Supreme Court in Formula One case, in which the makers of Formula One were found to have a permanent establishment in India. The Formula One case laid down three important tests for constitution of a fixed establishment PE. The first test was of stability, the second test was of productivity, and the third test was of dependence. At the end, the Supreme Court also held that the premise in question, namely the fixed establishment, should be at the disposal of the non-resident business entity before it could be said to have a permanent establishment. It is in this context that the case of Hyatt International has been appreciated by the Supreme Court. In the facts of the case, Hyatt International had a strategic agreement with two hotels in India. It was supposed to provide strategic advice, operational know-how, such that the hotels could carry on their business. It was argued by Hyatt International that they do not have a permanent establishment because they were only overseeing and did not have any day-to-day control over the hotel. This was contested by the tax authorities, which said that on substance, Hyatt International actually had a permanent establishment. The Supreme Court has agreed with the view of the Delhi High Court that yes, there is a permanent establishment in this case. Ultimately, on facts, the Supreme Court found that Hyatt International was having a say on the day-to-day operations of the hotel. It had control and oversight over the operations of the staff and was having these hotels at their disposal in the sense that it had complete freedom and flexibility to carry out its operation from those hotels. On the conclusion, the Supreme Court said that Hyatt International had a fixed place PE in India and accordingly it was subject to tax in India. This case reveals how minute facts and operational aspects determine whether an entity constitutes a permanent establishment, and hence it is an important milestone in India's international taxation rules.